I'm very sorry you've been kept waiting, Ms. Blears.
Perfectly all right.
But we're ready to start now once Mary has invited you to take the oath. You know, of course, you'll have heard me say it before, I have little doubt that you're talking to an audience probably numbered in three figures beyond this room, as well as to those who are variously in it. Mary.
Please state your full name.
Hazel Blears.
Take the book in your raised hand and repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Miss Scott.
I'm going to start with an overview of your career. So before becoming a Member of Parliament, you were a solicitor and you worked in a number of local authorities, including between 1985 and 1997 as the Principal Solicitor for Manchester City Council. Is that right?
That's correct.
And between 1984 and 1992, you were a Labour council member for the Salford City Council.
Yes, I was.
Now, in May 1997, you won a seat in Parliament to represent Salford, and that seat subsequently became the Salford and Eccles seat. Is that right?
That's right, my hometown.
And between December 1997 and October 1999, you were the Parliamentary Private Secretary to Alan Milburn, first at the Department of Health and then at the Treasury. Is that right?
Yes, that's right.
And can you tell us what the Parliamentary Private Secretary does and what their role is?
The role of the PPS, as they're known, is really to be a support to the Minister, to help him or her with relationships with backbenchers, with Members of Parliament, and to not quite be the go-between. I suppose the better word is a conduit, to make sure that the Minister is in touch, understands what the current issues are, what Members of Parliament are concerned about, what they want to raise. Going round the tea room is an absolute key priority. Alan and I used to go around the tea room after health questions, and that's a real way to keep in touch in an informal way. And also, as PPS, you would be with the Minister when he was holding formal meetings with Members of Parliament about issues that they wanted to raise. So it was a really good opportunity for me to understand how ministers conducted their business. Alan was a good role model, and my job really was to keep him very much in touch with current concerns so that he could think ahead in terms of policy.
In June 2001, you became the Parliamentary Under-Secretary for Health. Is that right?
Yes, I did.
And you held that role for just under a year until the 28th of May 2002. So from 11th of June 2001 to 28th of May 2002.
That's correct.
And just so that we can get the chronology in our heads, at that time, the Secretary of State was Alan Milburn, and the Minister at the Department of Health was John Hutton. Is that right?
Yes, that's right.
And Yvette Cooper was the Parliamentary Under-Secretary for Public Health.
Yes, she was.
And then Lord Philip Hunt was the Minister in the Lords.
Yes.
And then you tell us in your witness statement that as the Parliamentary Under-Secretary for Health, blood was not part of your portfolio, it was part of Ms Cooper's portfolio in the public health role.
That's correct.
But you also tell us that for a period, at least for some of that period, Ms Cooper was on maternity leave, and so you were called in to effectively cover for her at certain points.
Yes, I think the Parliamentary Secretary for Health is a bit of a role where you do a bit of everything, and you step in when required. I had my own responsibilities with GPs, pharmacists, therapies, all of that. But when Yvette went on maternity leave, there would be oral questions, there'd be adjournment debates, there'd be written questions, and I think probably PSH is the place where all that kind of landed up.
Now, on the 28th of May 2002, you were appointed as Parliamentary Under-Secretary for Public Health, so taking over from Ms Cooper.
Yes, that's right.
And you held that role for just over a year this time, until the 13th of June 2003, is that right?
Yes.
And if we just look at what you say in your witness statement about your portfolio, it's WITN 6658001, and it's page 5 of your witness statement. And if we look, please, at paragraph, page 6, sorry. If we look at paragraph 1.10 there, you say that as Parliamentary Under Secretary of State for Public Health, I was responsible for public health, protection and prevention, cancer, including Cancer Task Force, CHD and stroke, including CHD Task Force, tobacco, health inequalities, including Inequalities Task Force, drugs, alcohol and crime, Sure Start, sexual health and HIV, blood, teenage pregnancy, international health business, Food Standards Agency, BSc and VCJD, complementary and alternative medicine, and South Regional work. So quite a wide, diverse portfolio.
Yes, I think that would be putting it lightly. It was a very packed agenda. And some of those issues, not all of them, but some of them were very topical and very pertinent, if you like, to the programme of the department as a whole. Some of them were kind of trying to just keep the status quo, but others were really introducing change.
And again, during that role, the only change, as I understand it, to the other ministers were, obviously there was David Lammy had succeeded you as the Parliamentary Secretary to Health.
Yeah.
And during your time in that role, is it right to understand that Charles Lister was the head of Blood Policy Unit?
Yes, he was.
Now, on the 13th of June 2003, you moved to another role. You were appointed Minister of State for Policing, Security and Community Safety at the Home Office, and you were succeeded as Parliamentary Secretary for Public Health by Melanie Johnson.
Yes, that's right.
And about that time as well, is it right that Mr Milburn was succeeded by Dr John Reid, as he then was?
Yes.
And we've just been hearing from him, so although he gave evidence before you, his time was after you.
Indeed.
And the role you held in the Home Office, Minister in the Home Office, you held for about 3 years until June 2009.
That's correct.
In 2015, you left Parliament and you became a director of the Cooperative Group, is that correct?
Yes.
And since 2020, you have served as a social value specialist for the Nuclear Decommissioning Authority, and you're also a member of council at Lancaster University.
Yes, that's correct.
So I'm going to obviously focus my questions this afternoon on your role in the Department of Health, and in particular your ministerial role in public health. But before I do, can you tell us what knowledge you had about infected blood and the issues that this inquiry is concerned with prior to taking up your role as a junior minister in Department of Health?
Yes, I think you'll see from my witness statement that I coordinated a meeting when I was a backbencher to go to the Department of Health and raise some of the issues with which the inquiry are concerned about today. And I did that because these issues have been raised with me by a constituent. And I was the MP for Salford. I held regular surgeries, just as Dr Reid referred to, and my constituencies would be able to come and raise those issues with me, and they'd want to see me taking some action about the issues that they were concerned about. So I had some insight. I certainly didn't have any specialist knowledge, but I understood that my constituents were concerned, and therefore it was incumbent upon me as their representative to make sure those issues were raised.
Now, when you took up your role as a junior minister, did you receive any training or advice to help you understand how to actually perform as a minister?
Absolutely none. And I think that is common throughout government. And if you haven't been a PPS, being a PPS is at least some introduction as to how ministers should behave and what to do. But if you haven't done that, then it's even more difficult. And I think it is one of the failings of our system that we don't actually not train people so that you get them to think the same thoughts or believe the same beliefs, but actually in the practicalities of how to deal with officials and how to convene a meeting, how to get a result out of a meeting rather than it just be a talking shop, and how to follow those policy items through to achieve the kind of change that you want to see happen. I think we expect people to come to ministerial office almost ready-formed, and hardly anybody does.
And you say in your statement that you think it's unlikely you would have had a briefing on infected blood when you were Parliamentary Secretary for Health, but you would have been briefed on the McFarlane Trust and the Eileen Trust when you moved into the public health ministerial role. Is that right?
Yes, I can't recall when I was PSH having formal briefings, because obviously the brief was with Yvette rather than with me at that time. But when she went on maternity leave and I had to do a German debates, I'm thinking of the one with Gary Streeter about the Southwest, then clearly I would have got briefings from officials to help me with that kind of responsibility.
And when you took up the role of Parliamentary Secretary for Public Health, would you have spoken to Ms Cooper to get her steer on what the issues were that were facing you in that role?
I can't recall having that kind of conversation. Again, I think the dynamic in government is that, you get a phone call from the Prime Minister and he tells you, he asks you if you'd like to do a particular role in the government. It all happens extremely quickly. One day you're not the minister, the next day you are. And obviously when you get reshuffled, and Yvette would have moved on, there's, again, I think it's a failing that there isn't a period of handover. You're obviously going to reach your own conclusions about the issues that you're involved with, but having some insight from ministers who've previously carried out that role, again, I think would be a good thing.
And does that follow from that when you moved on, you wouldn't have had those kind of conversations with Melanie Johnson?
No, the way it happens is, it happens within an hour. Almost, you get the call and, very, very quickly, I was in the Home Office, as Minister for the Police. So, I stopped meeting doctors and started meeting chief constables within about, half a day.
We've heard evidence from Alan Milburn that there were regular ministerial meetings and also stock takes with the junior ministers, i.e. you. Would you have had regular meetings with the Permanent Secretary or with the Chief Medical Officer or Chief Nursing Officer as a junior minister in the Department of Health?
Not that I recall. I do remember the ministerial meetings that we had, which were not just political meetings. There was substance to those that Alan led. But I don't really remember having regular contact with the Permanent Secretary or the Chief Medical Officer in the junior roles that I was in at that time.
And looking back now, having had the experience of two junior ministerial roles in the Department of Health for round about a year each, and then a rather longer period as a minister in the Home Office, what are the advantages or disadvantages of having ministers in post for short periods of time as opposed to rather longer periods of time?
I think on balance, I would say that it's not long enough because sometimes the issues that you're asked to deal with are quite technical. They require a degree of knowledge. Certainly in the health department, you don't have to be, a great scientist, but you do have to understand the underpinnings to the policy that you're seeking to develop. And similarly in the Home Office, it takes you time. And by having 3 years in the Home Office, I was able to drive significant change. And it was obviously a more senior role as a Minister of State. And you really felt that you could implement policy and get that change. As a junior minister in a role for 12 months, It's very difficult to be able to do that. The one thing you can do is build on the work of your predecessors, because they will have been halfway through things when they get reshuffled. So you can look at that and see where it was going. Can you continue in that way? But again, I feel like I'm doing a bit of a seminar on improving government, but I think it would be advisable for people, if possible, to stay longer than simply 12 months.
I'm going to turn now to the calls for a hepatitis C payment scheme. I'm going to start with the report that the Hemophilia Society presented to you from their Hepatitis C Working Party. But before we do that, I'm just going to look at the briefing that you had for the meeting with them on the 12th of June, shortly after they'd presented the report. That's at DHSC 004 1305_037. So here we have a briefing to you dated the 10th of June 2002 about a meeting with the Hemophilia Society and Michael Connaty on the 12th of June. And we can see from the first paragraph that the Hemophilia Society had asked to meet with you and to present their report from the Hepatitis C Working Party, and that the report is being provided to you. We'll have a look at it in a moment and set out briefly what the report contains. Costed proposals for a financial assistance fund for haemophiliacs who were infected with hepatitis C through NHS infected blood. And then we can see at paragraph 3 that while the report was received on the 31st of May, it hasn't been possible for the officials to analyse it in any depth, and the Society are aware of that. So that's the context in which the meeting is taking place. And then if we go over the page, we can see that you're given some advice on developments in Scotland, which we don't need to deal with now, and then handling options. You're given 2 options: to adhere to the line that compensation is not payable to haemophiliacs infected with hepatitis C, or to agree to consider the report and respond to the Society in writing. So that's the briefing note. And then if we look at the report, we can find that at HSOC 305927. And if we go, please, to page 2, which is the executive summary, we can see how the Working Party was set up by the Hemophilia Society in September 2001 and compromises a QC specialising in medical negligence, consultant actuary, several specialist haemophilia doctors with particular expertise in treatment of hepatitis, and the Chief Executive Officer of the Hemophilia Society. And then paragraph 2, it was the Working Party was asked by the Society to devise costed proposals for a financial assistance fund to recognise the loss and suffering of people with haemophilia resulting from their infection with hepatitis C. And then if we go down to paragraph 4, we can see that the brief of the working group was to develop proposals for a scheme which would provide financial assistance on the basis of medical need and which would be relatively simple and swift to administer. And it says there that the working group looked at a number of different schemes operating around the world and decided that the Canadian HCV compensation scheme provided the most suitable model, and this was therefore used as the basis for their proposals. And then if we go over the page to page 3, we can see some explanation about the model of payments that they are recommending. Paragraph 8 be made according to the stage the liver disease has reached, with a range of formulae being used to calculate the amount of award. This will allow the payments to broadly reflect individual circumstances and to be allocated via an administrative system rather than a possibly more time-consuming and costly system of individual tribunals. And then paragraph 9 makes the point that there is allowance for dependents and families for loss of earnings, for inconvenience of drug therapy, etc. And then the estimated average cost of the scheme is set out at paragraph 10 over a 10-year period, 52.26 million per year, and then makes the point that that is a movable feast depending on what is or isn't included in the scheme. And then paragraph 12 makes the point that the calculations have been made on a pessimistic basis, and that they hope that with improved treatments there will be an improved quality of life for those infected that would have a knock-on reduction in the cost of the scheme. So if we then carry on looking through the report, we can see at page 4, paragraph 2, the remit, large paragraph there. In particular, the object of any scheme should be to recompense those who contracted hepatitis prior to 1st of March 1990, because they had contracted hepatitis C from infected blood products prior to that date, are not eligible to be compensated under the provisions of the Consumer Protection Act and the Product Liability Directive. Some, but not all, were parties to the HIV litigation, which was compromised in 1990, when the Macfarlane Trust was used as a vehicle to provide financial assistance to people with haemophilia and HIV. And at that time, those who were parties to the litigation in England, but not in Scotland, waived their rights to seek damages in respect of any of the hepatitis viruses, even though the litigation was not concerned with such viruses. So just pausing there, the point that's being made here by the Hemophilia Society is this right, that there are some of those infected by hepatitis C who have no other ability to obtain damages for the loss that they've suffered as a result of their medical treatment.
Yes, I think that's a correct description.
And then if we go, please, over to page 6, the report is talking here about how the proposals were developed. And if we look down at page 11, the point there that I just want to emphasise and draw your attention to is the second half of that paragraph. We also carried out a survey to establish the age bracket of sufferers, the nature of their symptoms, the date they were informed, tests and treatments undertaken, the marital status, household structure, work and social impact of the infection, and then the results of the survey and the actuarial calculations being set out in appendices to the report. So as well as it right to understand that this report is the Haemophilia Society trying to set out what the actual losses are and how those could be compensated.
Yes, and I viewed this as a serious piece of work by the Haemophilia Society. They've clearly gone to a great deal of trouble and effort to make the strongest case that they could, and I took it very seriously myself.
And then if we just complete looking through the report, we can see the levels of payment that they're suggesting at page 10. At the bottom, paragraph 25, we recommend, third sentence, we recommend that payment may be determined by the level of injury at the time that compensation is determined. Subsequently, if the compensated person moves on to another level, they ought to be able to return and seek assistance appropriate at that level. And then credit would be given for payments previously received. And then if we go over the page, we can see how that is worked through. We can see level 1, that is the model of those who are antibody positive for HCV, who have not progressed to a higher level stage of the illness, would get £7,500. Payment level 2, and that is, we don't need to turn it up, but it's at page 10 of the report. It's those that are HCV antibody test positive, HCV PCR test positive, would get £10,000. Payment at level 3, those whose liver shows fibrous changes, we get this from page 10, the definition of stage 3, Those whose liver shows fibrous changes or have received drug therapy or meet the criteria for such therapy will get £10,000, and paragraph 30, payment at level 4 is set at £40,000. That's clinical proof of liver cirrhosis, and then payment at level 5 at £60,000, decompensation of the liver or liver cancer. And then if we look through to page 25 and 26, we can see that on top of those payments for general damages, as it's called in the report, echoing the common law, we can see that the report is also suggesting that there should be compensation for loss of earnings. We can see that at paragraph 3, and if we go down the page, compensation for exposure to drug therapy. Paragraph 6, compensation for costs of care. Over the page, compensation for out-of-pocket expenses, etc., and for the deceased prior to 1st of January 2002 for dependents and so on. So different categories of compensation have been set out and worked through in that report. And then just completing the material that was being provided to you before I ask you any questions, we can see the briefing on the lines to take for the meeting with the Hemophilia Society on the 12th of June. We can see that at DHSC 0041305_038. And so just to put this in context and to remind ourselves of the date, this is a document that you would have received a few weeks into your new role as Parliamentary Under-Secretary for Public Health. And you're here being given the current lines to take on compensation. This government and its predecessor have held that compensation is only paid to patients when the NHS has been at fault, and that an exception to this rule is not justified in the case of haemophiliacs infected with hepatitis C. We deeply regret that so many people with haemophilia were infected with hepatitis C through blood products, but the fact is that as soon as a technology became available to make blood products free from hepatitis C, the NHS introduced it. There is therefore no justification for compensation based on legal liability for people with haemophilia and hepatitis C. And then a little bit later on, a little bit further on down we can see compensation schemes in other countries. You're given some information about schemes in Canada and Ireland. Canada and Ireland set up schemes because patients in both countries were being infected with HCV after it became possible to remove the hepatitis C virus from blood products. We understand that the Canadian scheme is limited to those people infected with HCV after 1987. In England, action was taken to virally inactivate blood products in 1985. Would you have understood from that paragraph that that after 1985 there wouldn't have been infection from blood products in England?
Well, I think what that's saying is that in England, action was taken to virally inactivate blood products in 1985, and therefore there was, as soon as the technology became available, so there was no element of negligence, if you like. And I think I would like to make some comments on the Hemophilia Society's report, if that's possible.
Yes.
The first one is to say I do think it was a serious piece of work, and people worked really hard to try and put this into the context where some payments might be achieved. But I think it does have a fundamental flaw, and that is that it's based on the Canadian scheme, and it's virtually taken from the Canadian scheme, item for item. It's almost a replica, if you like, of that Canadian scheme. And yet in Canada, there was negligence in that they failed to deactivate hepatitis C when the technology was available. And so for me, that was a fundamental difference between the Canadian scheme and this scheme. And the scheme that the Hemophilia Society presented was about damages. The first heading is general damages. Well, damages are payable when there is negligence and there's a cause for action. And so the whole thing, and this is not, I'm not criticising them, you know, the work that they did was tremendous, and they did it with passion and commitment. But actually, if you're talking about a financial assistance scheme, that's a very different creature to a scheme based on negligence. And they begin by talking about financial assistance, just as it happened in the McFarlane Trust and the Eileen Trust. That was financial assistance when people made applications, and they jumped to a wholesale scheme based on negligence, when in fact there was not a negligence cause to bring a legal action on that basis.
Or another way of looking at what the Haemophilia Society were doing would be to say that they were looking at what the needs of those that are infected actually were and what would be required to meet those needs. Would that not be another way of looking at it?
It could be, and it could be used as an illustrative example of what those needs might be in terms of personal support, but also support for dependents, the whole range of issues that they go through in their report. But I think if you read that in a very straightforward way, it is a scheme that's based on the Canadian scheme. It is, as I say, virtually a mirror image. And the Canadian situation was very different from the UK situation in that there was no negligence. And I think that then begins to eat away, if you like, at the logic of the Haemophilia Society's proposition.
Could we just go back up the page? Thank you. The second paragraph on the page reads, in the second sentence, the fact is that as soon as a technology became available to make blood products free from hepatitis C, the NHS introduced it. It would appear to follow from that after that the NHS supplied only products which had been so treated to those who needed those blood products. That would be follow, would it not?
Yes.
If, let us suppose a hypothetical question for you. If you had been told that in fact about half the blood products supplied by the NHS had not been virally inactivated and were not virally inactivated until around about 1989, 1990, would your answer to the questions about negligence and liability and fault have been the same as you've just given?
Well, I think, Sir Brian, that the technology to virally inactivate blood products was available in 1985, and it wasn't until 1991 that the technology was available to virally inactivate blood transfusions.
Yes, but I'm talking about blood products. Suppose you've been told, look, half the blood products we're giving people in England, England and Wales, may very well not be virally inactivated against hepatitis.
Well, if I had been told that, then it would be a very different situation, because if the technology was available and it wasn't used or it wasn't effective, then the people who had been infected would have had a legal claim for negligence and subsequent damages, possibly.
Well, I think that may actually, from a legal point of view, be going a shade far, but we can come back to those descriptions later on, or submissions can be made to me. But I just wanted to understand what your answer would be to that question, which, as far as you're concerned, is a hypothetical one. Thank you.
Can we turn over to page 2 of this annex and see what's said there about hepatitis C compensation in the Irish Republic? First paragraph deals with the contaminated anti-D immunoglobulin produced by the Irish National Blood Service. And the point's made there that's unique to the Irish Republic. And then it said this: the Irish government set up their hepatitis C compensation scheme following evidence of negligence by the Irish Blood Service. Compensation is therefore being given in very specific circumstances which do not apply in the UK. it does not create any precedent for us. Now again, pausing there, did you understand from this that what was being said about the Irish government scheme was that it was set up as a consequence of evidence of negligence, and so that was why it was different to the scheme, to what was happening in the UK?
Yes, that was my understanding, similar to the Canadian position.
And other witnesses have been asked about the veracity or the accuracy of that statement, and I'm not going to deal with that with you. But other evidence has been given about whether or not that statement is in fact accurate. Then if we move down to what you're told about the Hepatitis C litigation and the judgment of Mr. Justice Burton, which was handed down on the 26th of March 2001, we can see the background is set out in that first paragraph. In the second paragraph, you're told an out-of-court settlement was accepted by those claimants infected with hepatitis C after the 1st of April 1991, roughly the point at which the more reliable second-generation screening test became commercially available. This settlement was offered with the benefit of hindsight. NBA recognised that routine screening for hepatitis C might have been introduced slightly earlier, and then you're told that Mr. Justice Burton found in favour of the claimants, and that has been used by Lord Morris of the Hemophilia Society to press their case for compensation. Now again, just pausing there, reading that, did that give you cause to question perhaps the line that you're being told that there's no evidence of negligence or no evidence of fault on the part of government, when you've got out-of-court settlements being made because perhaps with the benefit of hindsight, routine screening for hepatitis C might have been introduced earlier?
Yes, I think the difference is that this was a product liability legislation, and therefore there was strict liability around this rather than fault or negligence, so the things are not entirely comparable. But we also have here that the date of 1991, and my understanding was that it wasn't until 1991 that there was a process to virally inactivate certainly blood transfusions at that point. But I think the circumstances of this were different and couldn't necessarily be read across.
What you're not being told in this note is about the findings that Mr. Justice Burton made in the litigation, that hepatitis C testing should have been introduced in March 1990 rather than September 1991, and that surrogate testing ought to have been introduced by, at the latest, the 1st of March 1988. Do you recall when and whether you became aware of those findings being made by the judge?
No, I don't actually recall. I remember this submission. I remember there being a distinction made that it was strict liability for product liability, and still, I suppose, reiterating the position that I'd been told, which was that these products and blood donations were virally inactivated as soon as the appropriate technology came into force.
So what's being said in this submission is there's a difference between England and Ireland because in England there's evidence of negligence. But you're also being told, well, actually...
No, because in Ireland.
Sorry, in Ireland, beg your pardon. You're also being told, actually, in this litigation, a concession was made that hepatitis C testing should have been introduced earlier, and you're being told that the claimants won the case, although you're not being given any details about the basis for that. Did that not ring any alarm bells with you?
Well, as far as I can recall, I was still being informed that there was no evidence of negligence in the way that the blood products had been treated, because this legislation was not about negligence. It was whether or not the product was up to the job of doing what it was meant to do. So it was in a different scenario.
Can you help at all with the nature of the proceedings in which there was the out-of-court settlement, which resulted in acceptance by claimants of settlements sometime after the 1st of April 1991? It's a rather curious paragraph, because the first paragraph and the third and fourth paragraphs are all dealing with the Hepatitis C litigation brought against the National Blood Authority under the Consumer Protection Act. This paragraph is not, on the face of it. It's dealing with unspecified proceedings, which resulted not in a hearing and a judgment, but in a settlement, on a basis in which the National Blood Authority has recognised that screening for hepatitis C might have been introduced on the 1st of April 1991 instead of the 1st of September 1991 when it was introduced. Can you help at all with the details of that?
Not at this stage, Sir Brian. I don't think I can. I don't think I have any further information in the documents that were supplied to me which would explain how that came about and what the detail of it was.
Yes. It's curious that it sits there under a heading which says judgment by Mr. Justice Burton. But there we are. Can you help at all, Ms. Scott?
So I don't know whether that is referring to the concession that was simply the concession that was made in the litigation. That tested. That's not what it says, but it may be referring to the concession that was made in the litigation to when testing ought to have been introduced.
Well, it's certainly that I understand was the position adopted during the litigation, at any rate.
Yes.
By those who were arguing the case on behalf of the National Blood Authority. But the out-of-court settlement it may be a reference to other proceedings involving HIV. I don't know.
Hepatitis C.
Yes, this is talking about, but it may be a mistake, is what I'm asking about, or whether you know anything about an actual settlement involving actual cases relating to hepatitis C, which was settled in 1991.
No, so I don't.
Thank you.
And then if we look on down the page, we can see compensation VCJD. The government is making £1 million available to fund care packages centrally and is strengthening the support for the National CJD Surveillance Unit. And then if we go over the page, we can say this does not change the long-standing policy in this country that compensation or other financial help to patients is only paid when the NHS or individuals working in it are at fault. We are not talking about no-fault compensation, but ex gratia payments for a group of people who because of exceptional circumstances have endured and are enduring a particularly harrowing ordeal. Now, again, just pausing there, was it your understanding that that's what was being sought on behalf of those that were suffering from hepatitis C, an ex gratia payment rather than compensation?
Well, this takes me back to the report of the Hemophilia Society, which I think was slightly confusing in that it was, as I said, I think in my evidence, it was a mirror image of the Canadian scheme, which had been formulated in response to an admission of negligence, and talked about damages and talked about common law principles, rather than something like the McFarlane Trust and the Eileen Trust, which was very clearly a financial assistance scheme. And I think it is important to have a distinction between those two approaches, because if you're talking about damages, and general damages and then specific damages, then you're into an area where you're talking about admission of liability, admission of fault. If you're talking about a financial assistance scheme, which is an ex gratia payment, then you're in very different territory where you're seeking to help people with the problems that they face, and rightly so, of day-to-day living because of what's happened to them through no fault of any organisation.
But you could have, could you not, an ex gratia scheme that was calculated on the basis of common law damages without that giving rise to any admission of liability, any admission that there was fault or negligence or anything of that sort. That would be possible, wouldn't it?
I suppose so. I'm not an expert in damages, but for me, when you start to talk about damages and compensation, I think you corrected yourself earlier, talking about recompense rather than a financial assistance scheme. I think those two things are quite different. As soon as you start talking about compensation, then you're looking at fault and blame, whereas if you talk about financial assistance, it is by its nature discretionary and ex gratia, and I think those two things are very different.
But it's right. Did you understand that the Hemophilia Society were seeking, when they put forward that scheme to you, that they were seeking not an ex gratia scheme based on common law damages or based on the Canadian scheme, but a scheme which required the department to accept legal liability?
Not in as stark terms as you put it there, but I think that the whole basis was about compensation, and I'm sure we'll come later to the issue of fault and no fault and the position that was developing, but I think the fact that it mirrored a compensation scheme where there was fault is actually an important issue.
And then just finishing off here, then we've got compensation, haemophiliacs and HIV. The special payment scheme for those infected with HIV was introduced in 1988. At that time, there were very strong public attitudes to HIV, of stigma and widespread fear of a new and untreatable fatal infection which was sexually transmitted. The payment scheme, the Macfarlane Trust, has continued since then. The same circumstances do not apply to hepatitis C. We accept that those infected in this way do face difficulties, as do other NHS patients and groups of people who unfortunately suffered unforeseen harm, which could not have been avoided. We aim to support those with haemophilia infected with hepatitis C through the benefit system, where appropriate, and through a number of projects which we support through the Hemophilia Society. So it's right, is it, here to understand that what's being said is that HIV is different to hepatitis C, and that's a justification for having a compensation scheme for those that were infected with HIV and not hepatitis C.
Yes, I think that's correct.
We don't have, and I'll come back to that issue later on this afternoon. Now, we don't have a minute of the meeting of the 12th of June that you had with the Hemophilia Society, but you tell us in your statement that from subsequent correspondence and from what you've seen of the documentation, it looks like you agreed to the second of those options that were given to you in that first document we looked at. In other words, you agreed to consider the report of the Hemophilia Society and then report back to them. Is that right?
Yes, that's correct.
And we will come back to how you dealt with that, but I'm going to go through this in chronological order. So that's one of the, as I understand it, first time that issues concerned with infected blood came across your desk as the Parliamentary Under-Secretary for Public Health.
Yes.
And then if we move forward then a month to July 2002, we can see your private office is being informed of the recommendations of that the Ross Committee were making in Scotland. And we've heard a little bit about that this afternoon. If we can look, please, at DHSC 004 2275_132. We can look at the email at the bottom here. This is an email from Charles Lister of the 29th of July to Mary Agnew. Was she in your private office?
Yes.
And it's there saying PSPH, that's you, should be aware that an expert group set up by Scottish Health Ministers will make a preliminary report recommending the establishment of a financial assistance scheme for haemophiliacs and others infected with hepatitis C through blood, similar to the HIV scheme established in the late 80s. We've not seen anything in writing, but this would suggest initial lump sum payments plus ongoing support for those infected, their widows and dependents. And then if we could go down to the last paragraph there, in the last sentence, it says there, in the past, the understanding has been that any policy changes on this issue would be taken on a UK basis. This position can no longer be guaranteed. Now, the inquiry has heard evidence about this understanding post-devolution that issues about compensation schemes would be on a UK-wide basis. Do you know where that understanding comes from and who generated it?
No, I'm afraid I don't.
Can we then turn to the Ross report itself, HSOC 0003349. Now, this is the preliminary report, expert group on financial and other support. It's known colloquially as the Ross report because the chair of that group was Lord Ross. And I just wanted to draw your attention, just so that it's clear what we're talking about as we go through this issue, to the what was said in that report on the issue of those who contracted hepatitis C. Could we turn, please, to page 19? Section 4, people who have contracted HIV or HCV as a result of receiving blood products or tissue transfer from NHS Scotland. And then 4.1 sets out what they were asked to consider. And 4.2, it says this: presently, people who have contracted HIV through receiving blood products or tissues from the NHS benefit from the arrangements via the Macfarlane and Eileen Trust, whereas people who contracted HCV under exactly similar circumstances do not. We believe the infection with HCV brings about adverse effects for the people involved, similar to those experienced by people infected with HIV. Furthermore, the way in which people were infected with HCV was exactly the same as those who became infected by HIV. We feel that this represents an inequity that should be addressed by introducing new arrangements. And then a recommendation is made by the Ross Committee for payments to be made for those who were infected with hepatitis C. Would you have read the Ross report yourself, or would you have relied on briefings from officials?
I can't recall reading it from this distance. I would normally read virtually everything that was across my desk, but I certainly read the Hemophilia Society's report in detail. I can't recall the same kind of detail from the Ross report.
I don't think we know whether, I don't think we have evidence, or at least I haven't seen evidence that the Ross report itself was sent to you. Certainly we have evidence that the recommendation was sent to you. But you don't recollect reading it, is that right?
Not the whole report.
Can you recall whether you were aware that the Ross report had found that those who were suffering from hepatitis C were suffering adverse effects in a similar way to those infected with HIV?
Well, what I do recall is that the scheme that was set up for people with HIV, which was the Macfarlane Trust and the Eileen Trust, was set up because in the case of HIV, unfortunately, the number of people who died was very, very significant, and almost death was an inevitable outcome of having contracted HIV. There was very little treatment available because of this was a new phenomena, and therefore the impact on the people who contracted HIV was swift and dramatic, and that was different in terms from the impact upon people who, tragically, also contracted hepatitis C, because for hepatitis C, there were a significant number of people who would clear the virus in any event. There was certainly better treatment available than there was for HIV, although that had a lot of room for improvement in terms of the treatment that could be given. And so there were some significant differences. They were not, if you like, comparisons on all fours between those two terrible, dreadful diseases in terms of the impact on the individuals concerned.
So that may be a justification for the decisions that were taken when the Macfarlane Trust was set up. What you're being asked, what I'm asking you about is as matters were facing you in 2002, were you aware that the Ross committee who had looked at this was saying, well, look, now in 2002, those that are suffering from hepatitis C are in a similar position to those that are suffering from HIV? Was that something that you were aware of?
If you mean by that the people who survived with HIV were in a similar position to the people who had hepatitis C, then that's one scenario. The other scenario is that the people who contracted HIV had very little prospect of living for a significant period after they contracted HIV initially, and therefore there was a difference in the positions between HIV and HCV.
I think the question you were being asked wasn't whether you thought yourself there was a difference between HIV and hepatitis C, but it was a question really whether you knew that the Ross report, those who authored the Ross report, thought that the consequences in terms of severity and impact were similar. So it's a question not addressed to the fact of whether they were similar in your view, but whether you knew that a body, the Ross report, which produced the Ross report, had thought that that was the position.
Well, I'm obviously aware of that now. I can't recall that being a significant issue for me at the time that I was looking at all the papers that came in. I can't remember taking that particular point from the Ross report.
Given that we just looked at some of the lines to take and the justification for not having a hepatitis C scheme and having an HIV scheme was that the position between the two groups of people were different. Given that that's one of the justifications, if you had known that piece of information, do you think that would have caused you to reconsider the policy and question it?
It's very difficult to answer the what-if questions about if I had known then, what I know now. Those are difficult questions, and I may well have wanted to delve further into what was being presented. I may well have wanted further information if that was the case. But I think as we come on to the other issues that happened, there was a certain context around all of this, around compensation and no fault and all of those issues that also had a bearing on the steps that I would take and the decisions that I would make.
Now, your witness statement tells us that after your office and you became aware that of the Ross report, that it was suggested that you might have a conversation with Malcolm Chisham, but that you don't recall having such a conversation. Is that right?
Well, not that I don't recall. I didn't have a conversation with Malcolm. This whole issue obviously was of significant importance to both the Scottish Government, but also to ourselves in the rest of the UK. And it very soon became a matter, I think I say in my statement, with involvement from the Secretary of State, from the Minister of State, and so it was much more appropriate for Mr Milburn to be in contact with Malcolm Chisholm as his opposite number in the Scottish administration.
I'll come on to ask you some questions about the discussion that they had in November. So is it right to understand that you don't think you ever spoke to Malcolm Chisholm about this issue?
Yeah, absolutely.
Can I then, just sticking with the chronology before we come to that discussion between Mr Milburn and Mr Chisholm, come to a debate on the 22nd of October 2002, SCGV 40254_078, and just pick up with you what was being said at that point about the government line after the judgment of Mr Justice Burton in the A and others litigation. So if we could turn over, please, to the second page. We can see this is an extract from a parliamentary debate, and that you are speaking about this issue. And if we can pick it up, please, at page 3, where you start talking about compensation, we can see the second paragraph down, I move on to compensation. And it's, you set out explaining the rationale of the government's rationale on NHS compensation. And I just want to pick it up at the paragraph at the bottom of the page there. So the Consumer Protection Act, and you're talking here about the A and others, implements the 1985 European Directive on Product Liability. As I've said, it's a piece of strict liability legislation. This means that there is no requirement of proof of fault, unlike the ordinary law of negligence. It's about defective products. The judge ruled that hepatitis C infected blood was a defective product and that irrespective of fault, there was product liability. That is why it appears that the claimants who fell within the window to which I have referred were treated differently in that they received compensation. And the window you're talking about there, is this right, was those that had been infected after the date that the Act had come into force, so the 1st of March 1988, because they could rely on the Act, and the date that hepatitis C screening was introduced in September 1991.
That's correct.
There is good legal reason why they became eligible for compensation. And so the legal reason you're talking about there is the fact that there is an Act that's come into force.
And it's my understanding that the other people who weren't able to proceed were time barred.
Yes, so I want to come on and ask you about this. If we then go over the page, we can see the government position as expressed by you in relation to those people. And that's the first full paragraph down there. You're talking about the constituent, I think, of Mr. Springer, who asked you, to whom you're responding. And you say this at the second half of this paragraph. The honourable gentleman's constituency is not the only person in that position of whom we are aware, and that position of somebody whose claim is time barred. But it would set a most unfortunate precedent in other litigation where there are time bars if the government were to accept that as a reason for awarding financial compensation, because it would be entirely out with the legal framework that applies to our decision-making in such matters. I recognise how hard that seems to individuals facing difficulties or family tragedies, but it is important that we maintain the integrity of the system and the rules by which we are bound. So is it right to understand from this that what you were saying was that for those that had not issued claims, who had been infected within the window of 1st of March 1988 to 1st of September 1991, who had not issued claims and were now time barred, would not be paid compensation by the government because the government was relying on the time bar.
Yes, and I think it's right that this is a very, very difficult situation because people obviously have been impacted by what has happened. But this is a time bar, and obviously this would be compensation without any acknowledgement of fault, and that's been a core issue around all of this, tragic set of circumstances. And I say there in the debate, I recognise how hard that seems to individuals facing difficulties or family tragedies, but it's important that we maintain the integrity of the system and the rules by which we are bound. Now, to some people listening to that, that sounds hard-hearted and insensitive. I can assure you that I was neither, and very, very conscious of the impact that this was having on people's day-to-day lives.
Can you recall at the time that this decision was being reached that the government would rely on the time bar? Can you recall whether there was any discussion about whether or not there was a moral case that would mean that the government should not rely on the time bar and should pay out for those people who, just by the fact that they hadn't issued proceedings within the relevant time, would now not be getting compensation which they would otherwise be able to obtain?
No, I can't recall a discussion of that kind.
Even in circumstances where the government was making ex gratia payments to those who had been infected with HIV by the same route, and payments to those who had been infected by VCJD by the same route.
Yes, and as I said before, there were some differences in terms of the impact, certainly of HIV, and in terms of VCJD, I think when Mr Milburn was giving evidence, he addressed both of those issues, and the way in which, certainly for CJD, death was almost inevitable and swift, and similarly for HIV, where death was very likely, and that there was very little prospect of people going on to lead longer and healthier lives. And therefore there were some distinctions between those and hepatitis C, where many of the people, not all of them, but many of the people did go on to either be clear of the virus or to be able to access better treatments that enabled them to live more of a normal life. I have no doubt that people still suffered tremendous problems, but I do think that the situations at that point were different.
But would you accept that following the judgment of Mr Justice Burton, the category of people who had received life-threatening infections as a result of blood and blood products was getting smaller and smaller? Those with HIV, ex gratia payments, those with VCJD, ex gratia payment, those that had been infected between March 88 and September 1991, if they'd brought proceedings, could get damages. And so the moral case is getting stronger and stronger, isn't it, for instead of looking at the differences, to look at the similarities and say, well, these people are suffering in similar ways, they've been infected by a similar route. We ought to rethink this compensation policy.
Well, I think that's a very strong case for the moral responsibility. The difficulty is in government and as ministers, then sometimes very difficult decisions have to be taken. And I'm sure we'll come on to the discussions that took place in the department around all of these issues. That doesn't for one moment mean that we didn't understand and empathise with the difficulties that people were experiencing. But the issue that the NHS compensates when there is proof of fault was a fairly fundamental principle in these circumstances, and we tried to help people who found themselves facing huge problems as best we could through treatment and support, and these decisions, as I say, are finely balanced and very difficult, not least for the people whose lives they affect.
Now, you've told us in your statement and again in your oral evidence that this was an important issue that was escalated to the Secretary of State, and we've heard evidence from Mr Milburn. There's an email from Charles Lister, which we don't need to go to, but which describes the Secretary of State's stance on compensation as being unequivocally opposed to it. Is that your recollection of his stance?
Yes, it is.
And in your discussions with him, would the focus have been and the concern have been about the cost of the scheme primarily?
Both about the cost of the scheme, but also about the precedent that it would set.
And how does that work? You have an HIV compensation. HIV compensation or ex gratia scheme, the McFarlane Trust, which is said not to have set a precedent, because if it had set a precedent, then there would be a scheme for those that have been infected with hepatitis C. How then is it said? How does one then get to the point where you say, but if we had a hepatitis C scheme, then that would set a precedent for all these other people that have been caused harm by completely different forms of medical treatment? Why would it set a precedent if the McFarlane Trust and the HIV scheme didn't set a precedent?
Well, as far as I recall, the thinking was that the more circumstances in which compensation is paid, the weaker becomes the position that compensation is not paid unless there is negligence and fault. Becomes very difficult to hold. And I think there are various statements from officials and indeed from discussions between ministers that if you have a series of exceptions to the general rule that there should be fault, then it becomes almost a slippery slope to the point where you have a no-fault compensation scheme. Now, you know, there are merits of all kinds of compensation schemes, and I am aware that John Hutton referred this issue initially to the clinical, the review of clinical negligence that Liam Donaldson was carrying out, that Liam Donaldson, in his report Making Amends, decided to reject that option. It would have cost the NHS an extra £4 billion. But I would say that report was 20-odd years ago, and it may be that there is, room for a new discussion around that. But at the time that I was a minister, then that principle was absolutely, held to, not just by officials, but by Secretary of State, by Minister of State, and was really quite a fundamental kind of line.
And how, if at all, was the moral case for a hepatitis C compensation scheme, the inequality point that the Ross report noted, inequality between those that had HIV and hepatitis C, how was that factored into those discussions, if at all?
I don't really recall there being a discussion around moral responsibility. In a way, that was assumed, that there would be moral responsibility, sympathy, support as far as it was possible to give people in any circumstances where their health had suffered as a result of the kind of circumstances that people with hepatitis C had. So it wasn't a case of, if you like, money versus morality in those stark ways, but it was recognising that if you simply had no fault compensation, then that would be a significant divergence from the position that had pertained for many, many years.
Do you recall whether there was any discussion with Mr Milburn or any concern expressed about what might happen if Scotland went its own way and had a scheme and there wasn't a scheme in England?
Well, I think what he says in the correspondence is quite clear, that he says that he thought it would be the slippery slope, that this is in relation to the Scottish system, that I think the phrase was, and you'll have it in your papers, that we would be scuppered, and that Malcolm Chisholm should, I think his phrase was, tough it out. So I think the Secretary of State's view was very clear.
I'm talking more about, I think the question wasn't very clear. Was there a concern expressed, or was the issue the fact that that would give rise to an inequality between those in Scotland and those in England? Did that factor into the debate at all?
Not that I recall.
Now, we know that Mr Chisholm and Mr Milburn had a telephone conversation at the beginning of November 2002. Did you have any role in either preparing for or attending that telephone conversation?
No, I didn't.
And we also know that following that conversation, steps were taken to get legal advice as to whether or not the compensation scheme, the ex gratia scheme, was a matter that was devolved to Scotland or not. Again, did you have any role in that process of getting advice?
I didn't have a role in getting that advice. That was, again, really Secretary of State and John Hutton who were involved in that. But I did understand the legal issues involved as to whether or not it would be a benefits issue and therefore reserved, or would it be a health issue and therefore devolved, and the involvement of the law officers. I was appraised of that as these events unfolded, but I didn't play a significant role in shaping those events. I was the Parliamentary Under-Secretary, and therefore I think, you know, Secretary of State and Minister of State were more involved with that than I was.
So I'm conscious of the time. I've probably got about 30 to 40 minutes of questions. I wonder whether we could it would be appropriate to take a short break, and perhaps I can use that time to cut down some of my questions, given the hour.
Well, that sounds an attractive proposition because of the hour. So we'll take a 20-minute break, shall we? And come back. That would mean at 4:45. So 4:45, we come back. Now, this is the first break in the course of your evidence. You're under oath. You must not discuss the evidence you have given or the evidence you think you may yet be asked to give with anyone, whoever that anyone is, but you can talk about anything else you like.
Thank you, Sir Brian.